Attorney General Pam Bondi testified before Congress yesterday about the Jeffrey Epstein files. Survivors of Epstein's abuse were sitting behind her in the room. When a congresswoman asked Bondi to turn around and face them, she refused. To understand why that matters, you need to know what the law required. Last November, Congress passed the Epstein Files Transparency Act. That's the law forcing the Department of Justice to release all their documents about Jeffrey Epstein and Ghislaine Maxwell. It passed 427 to 1 in the House. Think about that. In today's Congress, almost nothing gets 427 votes. This did. The law gave DOJ 30 days. Everything had to be public by December 19, 2025. Flight logs showing who traveled on Epstein's planes. Travel records. Sealed settlements where Epstein paid off victims. Internal DOJ emails about why they decided to charge or not charge people. Documentation about how Epstein died in federal custody. All of it. Congress knew this would implicate powerful people, billionaires, politicians, maybe foreign officials. So they wrote into the law, you cannot hide or black out information just because it's embarrassing or politically sensitive. You have to release it. The only thing DOJ was allowed to protect was the victims themselves, their names, their personal information, their medical records. So what did DOJ actually do? On December 19th, the deadline, they released a small batch of documents. Over 500 pages were completely blacked out. You couldn't read anything. Within 24 hours, some of those files just disappeared from the DOJ website. No explanation. 3 days later, December 22nd, they released 11,034 more documents. But people immediately figured out the redactions, the black boxes covering information, didn't actually work. You could copy and paste the text underneath, or use basic photo editing to see what was hidden. And what were they hiding? Not victim names, associates of Epstein. By early January, DOJ had released less than 1% of what the law required. Then on January 30th, 72 days past the deadline, more than double what Congress allowed, they dumped everything at once. 3 million pages, 180,000 images, 2,000 videos. Here's what was in that dump. Survivors' real names were left in the documents. Their nude photographs, images from when they were being abused, released to the public. Meanwhile, Les Wexner's name was blacked out. Wexner is the billionaire who owned Victoria's Secret, and the FBI once referred to him as a co-conspirator with Epstein. This violates another law called the Privacy Act from 1974. It makes it a federal crime for government employees to knowingly release someone's personal information without consent. The Supreme Court ruled that emotional distress alone is enough to sue. You don't have to prove financial damage. Each violation has a minimum penalty of $1,000. So every survivor whose name or photo was released without proper redaction can sue. And remember, the Epstein law itself required DOJ to protect victims. They violated both laws at the same time. The law also required DOJ to publish justifications for every single redaction in the Federal Register. They haven't done it. The law required a compliance report within 15 days listing who was named in the documents and what was still being withheld and why. Where is it? There's another law called the Administrative Procedure Act. It says government agencies can't make random, arbitrary decisions. They have to follow proper procedures. Releasing documents in waves with no explanation. Blacking out some names, but not others. Offering no justification. That violates this law too. At yesterday's hearing, Representative Jayapal asked all the survivors in the room who had never met with anyone from DOJ to stand up. Every single one stood. These are the victims whose cases DOJ was supposedly investigating. The department never even spoke to them. Jayapal then asked Bondi to turn around and apologize to these women. Bondi refused. Representative Thomas Massey, and he's a Republican, so this isn't partisan, told Bondi directly. Literally the worst thing you could do to survivors, you did. Bondi's response was to call him a hypocrite with Trump derangement syndrome. Then on February 2nd, the Deputy Attorney General announced there will be no additional prosecutions related to Epstein. None. Despite 3 million pages of evidence supposedly documenting a trafficking network. Why does the deadline matter so much? Because courts don't let agencies ignore statutory deadlines. When agencies miss deadlines under the Freedom of Information Act, courts have held them in contempt. When the National Archives missed deadlines for releasing JFK assassination records, they got sued and judges ordered them to comply. The Epstein Act didn't have any extension provision. 30 days means 30 days. DOJ took 72. So what can actually be done? The survivors can file lawsuits under the Privacy Act. There are criminal provisions for government employees who knowingly disclose their protected information. They can bring constitutional claims. The Fourth Amendment protects people from the government releasing their intimate information. They can file what's called a mandamus action, asking a court to order an agency to do what the law requires. Congress has options too. They can hold Bondi in contempt of Congress. They can cut DOJ funding until there's full compliance. Representatives Massey and Khanna have asked for a special master. That's an independent person appointed by a court to oversee the document release. Congress can also trigger an inspector general investigation to find out who actually made these decisions about what to redact and what to release. And there's still major stuff missing. The law required complete flight logs. Who flew where and went on Epstein's planes? Where are those? The law required internal DOJ communications about charging decisions, emails and memos explaining why they prosecuted some people but not others. Where are those? Full documentation of Epstein's death, not just autopsy reports, but incident reports, the investigation into how a high-profile federal prisoner died in custody. All of this was mandatory under the statute. DOJ declared compliance anyway. Look at what they chose to protect versus what they exposed. Wexner's name, redacted. Indian billionaire Anil Ambani's communications with Epstein about setting up meetings with Jared Kushner and Steve Bannon. Associate names redacted, even though the law explicitly said you can't protect people based on political sensitivity. But survivors' full names and nude photographs from their abuse, public. Bondi wouldn't turn around. The law said 30 days. Protect victims. Expose everyone else. DOJ took 72 days. Exposed the victims. Protected the powerful. The legal remedies exist. Privacy Act lawsuits, mandamus, congressional contempt, special master oversight. Whether they'll be used is the question. Right now, those survivors are still waiting.